Welcome, everyone. Good afternoon. You're on the Legal Line. My name is Dennis Kennelly, and we've got an hour to be with you today to deal with your employment law questions, entertainment law questions if you have any. And our guest today is Ann Learoff, who is a very experienced employment lawyer from Northern California. She's based in Redwood City, and we'll be talking with her a bit later, like 5 minutes or less. But if you're a small business person, this is a great show to focus on today because Ann represents a lot of small businesses, and companies like Safeway and Ralph's and Verizon and Southern California Edison, they pay their lawyers a lot of money, and they've got a lot of people helping them. But the small businessman is basically on his own, doesn't have a lawyer on staff, prefers not to call them if he or she can avoid it because we cost money. And Ann's going to give you some really, really helpful hints about how you can stay out of trouble and how you can help your lawyer out if somebody actually gets into trouble and gets sued. So we'll be on to that in a couple of minutes. But before we move on to that, we've got a special guest for a brief bit today, and that's Perry Smith, who's our news director here at KHTS, and just wants to alert us to what's hot in local news.
Thanks, Dennis. I appreciate that. And I think probably the biggest issue affecting business owners, small and large, most recently is probably this Chiquita Canyon landfill decision that the Los Angeles County planners made yesterday. And that's going to have impacts for the next 30 years at least for this area.
Okay, and what were both sides of that? What did one side want, and what did the other side want?
Sure. Just like any project that comes in, you had a group that was living near the project and had concerns about the impacts as far as traffic or potentially pollution, any of these things, and especially when you're looking at something like a landfill, you have the potential to increase that. So they were discussing the mitigation measures, and then also you have the business community that was very much in favor of this from what we could see. You saw that support. You saw from the Chamber of Commerce, which, Chiquita Canyon did a very good job of lining itself up with its partners in the community, with outlets like ourselves, who've supportive of each other in the past. And basically, those were the two sides, was basically the business community and then the local residents who had concerns, who were living near the landfill and probably most directly impacted by it.
Okay, and it's now been settled so that the landfill is going to be allowed to proceed.
Right. The county regional planners approved it, and then they put some conditions as far as on the hours and when the landfill can operate and take in people, and as far as they'll have 5-year checks now. Before there wasn't really as close to the oversight. It was kind of relying on self-reporting, and now they've brought in. They've made the community advisory committee. It sounds like they're going to be a little more active in it. So you'll see a little more local involvement, if you will, in oversight.
When's it going to begin to operate?
So it's been operating, but you're going to start to, and that was one of the things that the landfill was noting, is that through this whole process, they'd actually already seen that uptick in garbage disposal and the amount of trucks. So you might not see a big thing. It's just the real issue for them was that they were about to expire for their ability to legally operate because they're clean hand permit, and so now they have that okay.
Great. Well, thank you very much. I appreciate it.
Sure.
And we'll be welcoming you periodically on the show to update as to what's going on locally. And
well, a lot of times we have that nexus between our local news stories and then what you're talking about as far as giving information for business owners in the community. So we'd love to come back on anytime, Dennis.
Great. Well, glad to have you. Thank you. Ann Learoff, I've known a long time. We practiced law together in San Mateo County, not in the same firm, but ran into each other with great frequency. And we're trying to go back in our minds, and we think we had a case against each other a long time ago. We just did one recently and had a lot of fun with it and resolved it, as good lawyers do. And we hope to think of ourselves as good lawyers. But Ann, welcome to the show.
Welcome. I'm happy to be welcomed. I will tell you that for a moment I thought you had given me the hook before I even said a word.
What do you mean?
I got hung up on immediately as soon as you introduced me.
Oh, well, these things happen. We try and avoid technical snafus, but they do happen. So we won't name the guilty party, but it wasn't me. So why don't you give us a little of your background?
Well, yes, I've been practicing labor and employment on the employer side primarily, doing both advice and counsel work as well as litigation on behalf of employers for more than 30 years. I've had my own firm, and I've worked for a number of other firms, including a couple of big firms up in California. And I'm currently with a nice 5-lawyer law firm in San Mateo County called Farbstein and Blackman. We do a lot of defense work. We also do employer handbooks and all kinds of things like that. And we represent a lot of employers all over the state of California.
Great. And how do people, just if they want to get in touch with you, what's the best way for them to do that?
Well, the best way to get in touch with us is to call 650-554-6200. That's our phone number. Or alternatively, they can reach me at HAL@farbstein.com, or they can look us up on the web at www.farbstein.com.
And Farbstein is Farbstein, as I recall.
Correct.
Good, I got it right. Superb. Well, and speaking of numbers, we appreciate your phone calls. We need your phone calls. So the phone number is 661-298-5487, 661-298-KHTS. So feel free to give us a call with any question you have, and we'll either A, be happy to answer it, or B, try and tell you where to go to get the answer. So you represent a lot of small employers, and that is a difference because small employers tend not to be as well staffed legally as the big boys or the big girls. And why don't you tell us some problems that you've encountered and some helpful hints going into the future to avoid major pitfalls in one of the areas we were talking about off the air was wage and hour.
Well, wage and hour is a really big problem for particularly small employers. A lot of small employers, I would say mostly employers with 30 or less employees, do not have an in-house HR person or even an HR consultant that they talk to on the side. So as a result, they tend to do things more informally. In most instances, they know all the employees. In most instances, they don't really have problems until a problem actually develops. So they are very informal in terms of the record keeping for wage and hour. That is a fatal flaw because under the labor code, California requires the employer to keep records of all hours worked for a period of at least 3 years so that they have time cards that show when they came in the morning, when they leave at night, and when they got and when they got access to their lunch hour, and when they had access to rest breaks. And although the labor code and the case law does not require the employer to be a babysitter of the employees, the law does require the employer to make the time available. And let me tell you, it only takes one bad apple to go to an employer and say, hey, I didn't get my rest breaks or I didn't get my meal breaks. And an enterprising lawyer who can get his attorney's fees if he prevails will go after that employer and take the employer down and make the employer go out of business for nothing. It's a very simple thing to keep track of the hours. It's a simple thing to put language at the bottom of time cards that says, I hereby certify that I took all of my available rest and meal breaks, and have them sign it. That's all that an employer really needs to do.
Do you recommend time clocks?
Time clocks are good, only good as long as they're used. And the problem with time clocks is in order to document meal breaks, the employee has to clock in the morning, clock out when they go for the meal break, and then clock back in. And my experience has been that while employees are very good at clocking in the morning to make sure they get paid and clocking out at night to make sure they get paid, they're not so good at clocking in and out for meal breaks. And the employer really needs to keep an eye on that. If they want to use a time clock, that's fine. And in certain industries, a time clock really does work. It's just they have to make sure that there is some method of calculating or writing down in some form or other the half-hour unpaid meal break that they take when they work an 8-hour shift. And most importantly, that meal break has to take place before the end of the 5th hour of work.
Okay, so once the clock strikes 6 hours, you're screwed if you're an employer.
Well, you're screwed in that you have to pay an hour at the employee's regular rate as a penalty. Now, the regular rate calculation is another nightmare because the regular rate calculation includes bonuses that are not discretionary. So if you give your employees a bonus for every 20 days that they don't have any absences, that is included in the hourly rate. So let's say you pay somebody $14 an hour, just for the sake of argument.
Okay.
And then every 20 days, if they don't miss any time, you give them another $3 an hour. So you have to calculate that $3 an hour based on the pay periods as part of the regular rate. So that means that when you calculate the hour of premium that you give as a penalty, your premium is not necessarily exactly what they were paid. It could be more than that. And so it becomes a real nightmare of calculations. And in my experience, small businesses are not the best at math.
Exactly. And you said everything is informal. I would imagine discipline is also a problem that way.
Well, yeah, discipline is informal, and I would recommend anybody with more than 5 employees have some kind of a handbook. And I'm not intending that this is a pitch, but I can tell you that the California Chamber of Commerce has a pretty good interactive employee manual that anybody can purchase for a reasonable amount of money and then have a lawyer look over it after it's all done. And I will frequently recommend that to small employers because it saves the money of having a lawyer invent something from scratch based on policies that you have. And probably the biggest tip I'll give any employer who decides, yes, it's a good idea to have an employee handbook to set forth all of their policies is make it short. Make all of the policies that are important separate and have your employees sign them. For instance, rest and meal break policy should be signed separately. If you want to have an arbitration agreement in terms of employee disputes, make sure it's signed separately. Make sure that you have things that are clear. I mean, for instance, if you have leave policies, just make sure they're very clear in the handbook. No employee in the world, no matter how good it is going to read a 150-page handbook.
No, hopefully at best what they're going to do is when they need a particular section of it, when, for example, they've got a sexual harassment issue, they'll at least take the time to read what the handbook says about that. But
now, I would tell you also that if you have a large complement of Spanish-speaking employees, it's a good idea to not only have the handbook in English but also have it in Spanish. And I believe that the Chamber of Commerce has one in Spanish as well. So it's easy to do that. And most importantly, when you give an employee a handbook, make sure they sign an acknowledgement that they've received it and they've looked at it. They don't have to read it in great depth, but that helps. I can't tell you how many times that's helped me in litigation, because in almost every employment handbook in California, there will be 2 things that are of critical importance. Number 1, employment at will, which means that you can, you as an employer can terminate somebody with or without cause and with or without justification at any time, and the employee can leave with or without cause, with or without notice at any time they want to. And that's important. And the other thing that's important is the handbook is not a contract of employment.
Exactly. So it's just guidance.
Absolutely, guidance, and those policies can be changed at any time in employment owners' discretion. So those are important things to know.
Yeah, and I would also suggest, I tell my management clients that if you've got a handbook, just don't put it away. You've got to review it periodically and have it reviewed periodically because laws change.
I would say a rule of thumb is every 2 to 3 years, have your attorney look at it to make sure that there are no, particularly in California, because the leave laws in California slightly change from year to year. Not always, but some of them really do change. And a couple of years ago, there were about 4 or 5 different new leaves that were added. And people who just simply have a handbook that they just sit around with, they don't know that. And frankly, if the handbook is out of date, it's of no use to you. The other thing that a handbook is of no use to you is if you don't strictly follow the procedures in the handbook. I can't tell you how many cases I've had where an employer has this beautiful progressive disciplinary policy in the handbook, which, by the way, I don't recommend, and then they never follow it. And then all of a sudden they get sued, and what happens is the employer is in the position of saying, well, yeah, we have this progressive discipline, but it only applies to our union employees. It doesn't apply to our management employees. Well, where does it say that in the book? Nowhere.
Exactly. And, yeah, I agree with you. I assume your logic on progressive discipline is it tends to tie the employer's hands.
Well, what it does is it implicitly, if not explicitly, negates the employment at will, which is very important to employers in California. Very important. Because employers in California can sneeze, and an employee will say, that's discriminatory. Or, you're disciplining me because I'm this, that, or the other thing. And it just doesn't... It doesn't help you if this is someone who has a poor performance history and you haven't documented it and you haven't gone through the process. It's better for you if you don't have a specific formal process, but if you document poor performance. Because I guarantee you, in 80% of the cases that I've handled in court, 80%, that's a lot, that's a large percentage, the lawsuit comes about for one of 2 reasons. Number one, the employee is surprised because they have absolutely positively no idea that they're about to be fired. Or number 2, the employee simply thinks that they know they're about to get disciplined, so they take a preemptive strike and they file a lawsuit or a claim of harassment of some kind in order to try to act as subterfuge.
No, understood. Getting,
discipline.
Yeah, basically one jump ahead of the sheriff.
Correct. And they do that, and 80% of the cases that I've seen that go to court are that.
Yeah, and as a plaintiff, when I'm representing plaintiffs, employees, I feel a lot better when there's no paper in the file. That makes me feel really, really good. And we will get back into much more detail on this and other wage and hour and sexual harassment subjects after the break. You're on the legal line with Dennis Kennelly, and we'll see you when we get back.